First up, we're in Ann Arbor, Michigan for a motion hearing. 39-year-old Michael Young, who pled guilty to failure to stop causing serious impairment, has been sentenced to 40 days in jail and 18 months probation. 3.5 years earlier, according to police, Young drove his truck off the road through a ditch and into a car that was parked in a driveway. Inside the car was 76-year-old Patricia Vital. She'd been visiting one of her daughters when the accident occurred. Young called a friend for a ride and fled the scene before police arrived. Patricia was taken to a nearby hospital, but died from her injuries the next day. With the help of eyewitness accounts, police identified Young as the driver and he was arrested. One witness claimed to have smelled alcohol in his breath, but Young declined to speak to police. And since too much time had passed since the accident, his blood was never tested for alcohol. Young was originally charged with failure to stop when at fault resulting in death and failure to stop causing serious impairment. But the first charge was dropped when he agreed to plead guilty to the second. Today, Young appears before Judge Patrick Conlon, having only served half of his 40 days in jail. But because he's scheduled for shoulder, neck, and leg surgeries, which could require a lengthy recovery time, Young is asking the court to adjust his sentence.
You're asking for early discharge. You're still kind of on the hook to serve 20 days in jail. So one possibility may be that if we were to waive this requirement that you serve the 20 days in jail, I would actually extend your probation and you would be on a scram and a GPS tether.
But the judge is troubled by reports from the victim's family that since the accident, Young has been spotted at the local bar while on probation.
Can I comment on that? Sure. There's a restaurant. It's the only one. I don't know if you've ever been to Bridgewater. It's a tiny little town with.
I do understand that, but just remember, sir, we're here today because of the death of a family.
I understand. It's the only place around to go to lunch. There's nothing to do with drinking, and I understand. I mean, I feel for everybody here, and I don't know where else to go.
You're asking for early discharge from probation. I'm willing to extend your probation and waive one of the requirements of probation that you serve another 20 days in jail.
The prosecutor, Jessica Blanche, is not on board with this solution.
But there are victims who have lost a family member in this
For
case.
sure.
They were under the impression he was sentenced to a particular sentence. He was to serve this amount of time. For them, there's this closure here, and now we're saying, well, let's be accommodating. He's going to the tavern, I get it. Oh, well, there's not enough places to be right. Well, you can get takeout. I mean, this is a serious offense where someone lost their life.
Like, you're 100% right, but is him serving 20 days in jail better guarantee that he's not going to hurt anyone else than extending his probation further with conditions to show that he's sober?
Can I say?
Not really, sir. After I hear from the victims, I'm either going to give you a choice or not.
Before Judge Conlon makes his ruling, Patricia's daughters address the court.
He got sentenced to 40 days. 40 days. I've lived every day of my life being forced to relive that night because he killed my mother in my front yard in front of my children. He didn't even stay until help arrived. He chose to run away. It feels like an insult to my mother's life and to my family.
I agree with my sister that 40 days, it is an insult. Yes, I know she was 76 years old and she was older, but she had a lot of life left to live. The sentence, in my opinion, was so lenient to begin with, and to be discharged early, it's just insulting.
After hearing their statements, the judge makes his decision.
In light of what the victims have brought to me, I'm not going to make any changes to your probation condition, and I'm not going to grant you early discharge. But I'm going to deny the motion.
Young remains on probation and still must serve the remaining 20 days of his jail sentence. Next, we're in Detroit, Michigan for a pretrial conference. 26-year-old Micah Bradford has been charged with 3 counts of assault in 2 different cases. She pled not guilty to all 3 counts, posted a $5,000 bond, and was released. Today, she appears before Judge Elenice Bryant to discuss next steps in the case. As the hearing begins, Bradford experiences some technical difficulties.
Judge, it looks like her device is not connecting.
But Judge Bryant is more concerned with another matter.
All right, Miss Stevenson, you spoke to Miss Bradford in the breakout room, and now she's laying in the bed, attending court. That's
Absolutely,
that's so unacceptable and so ridiculous. I don't even know what to say. That's so unacceptable and ridiculous. I'm sending her back to the breakout room.
The judge moves on to other cases until the defendant finds a different location. A few minutes later, Judge Bryant recalls Bradford's case. This time, the defendant appears standing at a kitchen counter.
How are we proceeding?
Your Honor, on behalf of Ms. Bradford, we would first offer the court an apology for Ms. Bradford's prior appearance without offering this as an excuse. Just wants the court to know she was not lying in bed. She was on her bed trying to charge her phone. That won't happen again. She'll charge her phone.
She was laying in the bed. I don't care what she was doing in the bed. She was clearly laying in the bed. She could have charged her phone and not be lying in the bed. Second of all, once the court brought to her attention that she was lying in the bed, everybody else that was uninformed enough to come to court in the bed would get up out of the bed when the judge says, you're in the bed.
Bradford does not seem to appreciate the judge's comments.
Continue, Ms. Stevenson, but she was laying in the bed. Laying in the bed. She was laying down in a bed. I said, ma'am, anything you say probably is not gonna work out good for you. Ms. Stevenson?
Thank you, Your Honor. So, Ms. Bradford, ma'am, if you could just listen attentively to what the court's saying. On behalf of Ms. Bradford, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter?
Yes, Judge. So the people respectfully request the court to adjourn both cases for pretrial conference to give the complainant witnesses one more opportunity to appear.
The court is going to deny defense counsel's motion for dismissal. The court will set the pretrial conference for Wednesday, June 14th.
Before the hearing ends, the judge has a few more words for Bradford.
Ms. Bradford is having extreme difficulty in attending court properly. She currently has her hands on her hips, and I'm having a difficult time dealing with Ms. Bradford via Zoom. And then in response to me addressing the hands on the hips, then she folded her arms in front of her. If you are going to come on Zoom, you're not going to attend court inappropriately. It's just not going to happen.
With that, Judge Bryant adjourns the case. If Bradford is found guilty on both charges, she could be sentenced to at least 90 days in jail. Next, we're inside Calvert County Circuit Court in Prince Frederick, Maryland. Police have been called because 42-year-old Dawn Marie Keene is protesting a county mask mandate by refusing to wear one in the courthouse. The mandate ordered during the COVID-19 pandemic by Chief Judge Joseph M. Getty. Police have asked Keene to leave several times, but she's not cooperating. A deputy arrives at the scene with his body camera rolling.
What's up, guys?
The young lady's refusing to leave the premises.
Why?
She doesn't want to wear a mask. Now she doesn't have business apparently here either, so she just wants to stand here without a mask.
If you have no business here, you need to leave the building.
Why? My business is to ask these men why every time I come here, or I go to school with my kids, or I go to practice with my kids, we have to wear a mask. You are all here to protect me as much as you're here to protect everyone in this building.
Okay.
That's what you signed up for.
Okay.
I should not put a mask on my face. It affects my immune system.
Okay.
I'm a statistician. I look at the data. There is no data out there to prove that I need to have a mask on my face, nor should my children.
You can write a letter to your congressman, you can write a letter to the commissioner.
We can sit outside and talk all day, but you gotta get out of a security area.
here and tell me what you're gonna do, but
We're gonna arrest you. What's gonna
You're
happen?
gonna get arrested. You're gonna get arrested.
Told
No,
them what's gonna happen.
Yeah.
how am I trespassing if I
I
paid
just
for
told
this
you to
time right here?
leave.
You have no business in the building, ma'am.
all right, listen, man. We body cameras record everything that's going on. Okay. I'm advise you now to you can wave all you want.
Here,
You need to
record this
You need to leave the
for me.
building. You need to go to-
Dedicated to the glory of Almighty God in memory of Calvert County men and women who served their country with valor and honor. Is this valor and honor? Put a mask on your face?
All right,
I'm not
go.
gonna cover my face, okay? I'm not doing it. God gave me this face and I'm gonna show it. I'm not getting
Leave the
out.
building.
Don't touch me. You
Leave
have
the
no
building.
right.
Yes, I do.
No,
Leave the
you
building.
do not. You do not have the
I'm
right
asking-
to touch
I'm asking you to
me.
leave. I'm asking
not
you to leave.
leaving.
I'm telling you
I
to
will
leave now.
not
All right,
leave.
cool. You're under arrest for trespassing.
Do not touch me.
Out of the building.
The officers place Keene under arrest, but she does not go quietly from the courthouse.
Don't rip my coat because you'll buy me a new one. Absolutely disgusting. Shame on you. Shame, shame, shame on you. You have children? Do you have children?
Why are you worried about my
What a
myself?
shame.
Why?
Because they're going to end up in Nazi camps.
It seems the officer doesn't appreciate the suspect's comment.
Are you a veteran or something?
My family are.
Okay, I'm a retired veteran, so that's probably not the way you want to go with that. You understand?
Well, I mean, that's what you're doing right now.
Definitely not.
Yeah, it is.
Before she's put in the police car, Keene lands a few more comments.
I didn't touch you. I didn't hurt anybody. I stood there and spoke my mind because this is wrong.
Yeah. But you also didn't leave when you were told to go to courthouse.
That doesn't matter. I don't have to leave for not wearing a mask on my face.
For here you do. Yeah.
No, I do not. That's my courthourse. I pay taxes for that. This is ridiculous. Shame on you all. Shame, shame, shame.
Watch yourself. Hang on. Hang on.
Keene was charged with trespassing and disorderly conduct and released on her own recognizance. She later pled guilty to disorderly conduct and was sentenced to 18 months probation. The trespassing charge was dismissed. Next, we're in Amarillo, Texas for an arraignment. 64-year-old Eddie Ray Gibbs has been charged with possession of drug paraphernalia. 2 days earlier, police responded to a criminal trespass call at a fast food restaurant. Gibbs was at the scene, and when police searched him, they discovered a glass pipe and small amounts of crack cocaine in his pants pocket. Today, he appears without a lawyer before Judge Laura Hamilton to enter a plea.
Hi, Mr. Gibbs. How are you today?
Hi. Hi, Judge.
How are you today?
I'm blessed and highly favored, man.
Well, isn't that wonderful? So here's the deal. You've got this one possession of drug paraphernalia from July 8th. How do you want to handle that?
If I may.
You what?
What my doggone pants?
What?
That's right. Gibbs is claiming the pants he was wearing, where the drug paraphernalia was found, do not belong to him.
They want my pants, so I don't even do drugs.
Gibbs makes his case to the judge.
My pants, they're all dirty. So I had to wear my roommate's pants.
So you put your roommate's pants on.
Yeah.
And your roommate's pants had stuff in the pockets.
Yes, I didn't check.
But so who was in control of that situation at that time?
I was.
I know. I'm so sorry, Mr. Gibbs.
I understand. It's so fine. It's all right.
You can plead not guilty, no contest or guilty. You're welcome.
Guilty because I had them on. So.
I know. Well, but you can come in, if you want to come in and talk to the prosecutor to see if you can work out a different deal. If you are concerned about the conviction, you're not concerned about that?
I have to pay some accept whatever the consequences are, ma'am.
Didn't you tell me you're a preacher?
Well, I am trying to preach the word. Okay. It's called Divine Fellowship of Love.
Well, I don't want to do anything that's going to negatively affect your ability to do what you want to do that way.
Yes, ma'am.
So if you want to come in and talk to the prosecutor, maybe she would offer you deferred. You'd have to pay some money up front.
No, ma'am, Miss Plant, all I want to do is get it over with. Like I say, they wasn't my parents, so what? I accept what it is, and I'm ready to just move on and get my life right. My life is right. I'm doing God's work.
I guess from in my mind and in your mind, God knows. God knows.
He knows.
So,
he knows. Yes, ma'am.
Okay. So are you pleading guilty or no contest?
I'm pleading.
Despite Judge Hamilton's advice, Gibbs sticks with his plea.
I plead guilty.
Okay. Yes, I'm going to find you guilty, and I'm actually going to time serve you on this. So I'm going to give you the benefit of the doubt on that. I am going to adjust your fine to $219. Your court costs are $81. Your total's $300, and you are time served. Okay?
Yes, ma'am. And I'll be there at 2 o'clock today, tomorrow.
Nope, you're done.
Gibbs doesn't seem to understand that the judge has sentenced him to time served and that he's free to go after paying his $300 fine.
You don't even have to come in, okay?
Well, amen. I love you.
Thank you. You have a good day. Thank you, Mr. Gibbs.
Next, we're in Quincy, Illinois for a sentencing. 39-year-old Tim Bleefnick has been convicted on 2 counts of first-degree murder and 1 count of home invasion. 6 months earlier, police say Bleefnick was going through a heated divorce with his 41-year-old wife, Becky. One night, while their 3 children were sleeping at Bleefnick's house, Bleefnick went to Becky's home. Investigators say he broke in through a window and shot Becky 14 times. Her body was found the next day by her father. Bleefnick was an immediate suspect since on the night of the murder, Becky had texted her sister saying that if she was ever harmed, police should investigate her husband. When they examined Bleefnick's phone, police say they discovered searches on how to make a homemade silencer and how to open a window from the outside. Bleefnick was charged with murder and home invasion. He pled not guilty. The trial lasted 6 days, but it took a jury just 4 hours to return with a verdict: guilty on all charges. Today, Bleefnick appears before Judge Robert Adrian to hear his sentence. But first, his attorney, Casey Schnack, makes an appeal for leniency.
It is our position today, Your Honor, that the law is designed to punish those with life without parole only for the worst of the worst. But if you look at the life Tim lived prior to February 23rd, I believe that Tim should be given credit where the law allows credit to be due. Tim obtained an education, a college education. I would be proud if my son obtained a college education like Tim did. He was fully and gainfully employed. I would be proud if my son were fully and gainfully employed. He has no prior criminal record, which is something that the court has to consider.
The next person to speak is State Prosecutor Josh Jones.
The defense asks for a sentence of leniency, hope, and mercy. Your Honor, I ask that this court today show this defendant the same leniency that he showed Becky Bleefnick when he fired 14 bullets into her body. I ask that this court show him the same hope he showed his wife when he stood over her and fired that gun again and again and again. Show him the same mercy he showed her when he left her to die completely and utterly alone.
Thank you, Mr. Jones. Mr. Bleefnick, before I sentence you, you have a right to make a statement to me. Is there anything you'd like to say?
No, Your Honor.
Before Judge Adrian imposes sentence, he speaks directly to the now convicted killer.
Mr. Bleefnick, you researched this murder, you planned this murder, you broke into her house, and you shot her. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11,  , 12, 13, 14 times. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 times. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 times. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 times. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 times. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 times. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 times. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 times. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 times. 1, 2, I don't know how long it took you to do that. Some of those shots were fired while she was lying on the ground. And you did all of that while your children were upstairs at your house, lying snug in their beds.
And with that, the judge sentences Bliefnick to life in prison. He'll have no chance at parole. The 3 Bliefnick children are currently living with Becky's family. Next, we're in Flint, Michigan for a civil suit. The plaintiff, 43-year-old Amy Diacovo, owns a house cleaning company. She claims she's owed payment of $672 for work her company performed at the home of the defendant, 29-year-old Goldie Kaz, who appears today with her mother. The judge is Christopher Odette.
Okay, this is a claim for $672, am I correct?
Correct.
And she refuses to pay for the services.
Correct.
Is there anything in writing, an agreement of any sort?
Yes. I never signed anything. No, I texted it in the text. I'm speaking. They did a walkthrough with her and her mother. The mother was demanding different things that they wanted done. My mom was not there.
The judge does not appreciate the interruptions by Kaz and lets her know about it.
This is your last time I'm going to tell you. She's talking right now. If you're going to talk and she's going to talk, then I'm not going to permit you to talk. And the only thing I'm going to hear will be her version of this.
Okay, I want to do it again.
So just wait.
Diacovo, who's joined by the employees she says cleaned the home, continues her statement.
These girls went through top, bottom, left, right, crevice of that home. It's a very large home. These girls work very hard. I get compliments on all of their jobs.
Let me ask you this. Was there an agreed on price?
Yes, there was. It's in writing.
Okay. And are you saying that the homeowner tried to change the price?
Yes, she did. She demanded that I change it to $400, that's all she's paying. I'm not lowering my cost.
Ms. Cass, what's your response here?
Okay. I did not know the amount of ladies they were bringing and how much it was going to cost that much only one day. They sprayed some cleaning product on the lamp, and when I turned on the switch, it made a fire. And then I have a thing where she said, I agreed to 400. I was like, okay, and then they don't speak English. I don't understand them when they were in the house. Some of the girls here. Because when I speak perfect, you only. When they spoke to me, they weren't speaking English. Oh. And then they stayed for like so many hours. I didn't know that they were going to be there that long.
Did they have a walkthrough?
Yeah, and I did mention stuff I didn't like. And then they didn't like.
Did they follow up and fix it?
No.
Is that correct?
No, it is not.
Diacovo seems to be frustrated by the defendant's accusations.
She asked me how long they were going to be there. And I said they will be there the complete day. She clearly states what I charge per hour. She clearly let them out of the house and locked the house up after they left. She just testified that she did the walkthrough. None of them speak English. This is like a show right here. Read the whole conversation. She's a mess. You're a mess. That is so She's a mess.
Judge Odette gets back to the subject of dollars and cents.
So you're saying 672 and you're saying nothing?
Yeah, but I did say but I would like to do nothing because what's going on.
How do you do nothing if the services were provided?
Because the way that they did stuff, and the way that they burned my lamp, they damaged my home. And I feel like I should get money for damages. Can I see pictures of that? Yeah, I will get some. I didn't text them to you. Present them. I can get them. I don't have. You should have been prepared for what?
The judge has heard enough and is prepared to make his ruling.
I'm going to rule in favor of the plaintiff. I'm going to find that the sum of $672 based on the testimony I've heard. It would appear to me, more likely than not, that Thorough Cleaning Company did provide services that were rendered in a way that was satisfactory.
Thank you. You have a great day.
Kaz was ordered to pay the plaintiff $672 for the cleaning services, plus an additional $119 in court costs, for a total of $791. Next, we're in Monroe, Michigan for a child custody hearing. The plaintiff, Tyler Zonka, has a 5-year-old son with Kaylee DeMerchant, who's facing 2 drug charges in another county. Zonka was recently awarded full custody, and today his attorney, Derek Jacques, has asked Judge Mark Braunlich to continue that order and limit DeMerchant's visitation rights. But the judge has decided to adjourn the proceeding until DeMerchant consults with an attorney. Also on the call is mediator Joshua Walker.
Ms. Merchant, do you have any objection to the court adjourn this so you can talk to an attorney?
No, sir.
Okay. Mr. Jocks, anything else you want to add?
We would like to bring to the court's attention is that during a Zoom meeting with Mr. Walker that Mr. Merchant felt it appropriate to give us the middle finger, and her background picture on her Zoom when her camera's turned off has the words, "You have my permission to die" on it, which we did not think.
What are you talking about? I did not say that.
Okay, well, let's hear you up.
I did not say that. No, what are you guys talking about? That is hearsay. Thank you.
All right. Well, if it's on your background, you probably want to remove that.
I did not. No, you can review it, Mr. Judge.
The judge moves on to DeMerchant's visitation rights.
What about the FaceTime between mom and in the interim? Any objection to that, Mr. Jocks?
You are really something, huh? You think I'm going to say that in the court of law?
Mr. Merchant, the court is trying to inquire. Maybe we could do some FaceTime between you and your son in the meantime.
Yeah, that's wonderful.
Are you being cynical or are you being serious?
I'm being emotional, Your Honor. I apologize.
Okay. Mr. Jocks, any reason why we cannot set up a couple of maybe 2 days a week for mom to facilitate, initiate a phone call to...
Mr. Zonka doesn't have a problem with it. Our only concern would be about the PPO.
There's a PPO?
Zonka has filed a PPO, or personal protection order, against DeMerchant, which prevents her from physically seeing her ex.
Excuse me! Tyler put a PPO against me.
Hold on. This is a PPO prohibited contact between you and Mr. Merchant.
I believe it permits contact only...
Wow, are you a...
We're going to mute you, ma'am. You're interrupting the court proceedings.
After a brief pause, Judge Braunlich attempts to return the conversation to the proposed video calls between DeMerchant and her son.
Okay, we can unmute Mr. Merchant. Mr. Merchant, the court would like there to be some face contact. The court's suggesting Tuesdays and Thursdays at 6 o'clock.
Yeah, so I can see him on video?
Yes.
Because Tyler has a PPO. What does the PPO entail, please, sir? I don't
have that in front of me. Another judge entered that.
Okay. And like, what is it pertaining to? Please tell me, one of you guys, your attorney or Tyler, that would be great.
You'll probably serve that. You can always come down to the county courthouse, get a copy of that from the clerk's office. Another judge entered that.
I want to know what it entails.
I wasn't aware until now, but the court's going to include
I wasn't aware of it either, sir. He dumped on me. I also want it stricken from the record that I said, I hope he dies. I don't even know what that is.
Contact or not, Mr. Merchant? I'm trying to accommodate some relationship between mother and child. Do you want FaceTime with or not?
Yeah, that's wonderful.
All right. So you'll initiate it 6 o'clock on Tuesdays and Thursdays. So you can call 6 o'clock tonight to Tyler's phone number, and he'll put it in front of so can talk with you for a short time. Obviously, a 5-year-old's not going to talk real long.
How long am I allocated a phone call with my child?
Well, be reasonable. I mean, obviously, if he's bored, probably 5 minutes. I mean, the 5-year-olds are not going to talk for a long period of time, so try to engage him.
Can we do 20 minutes?
There is no time limit, ma'am. There's no time limit. Be a reasonable, sensible adult parent.
Judge Braunlich adjourns the case until DeMerchant can consult with an attorney.
Back August 1st at 1:30. Hopefully, we can address some parenting time at that time.
What a piece of...
That will conclude this matter. We can zoom out.
Thank you, Your Honor.
You're welcome.
What a piece of you are.
Mr. Merchant, don't speak that way in court.
He knows what he is.
DeMerchant was a no-show at the August 1st hearing, so Zonka retained full custody of their son, though she still allowed video visitations which she's been attending regularly. The case is now closed, but DeMerchant can request a review in the future. Next, we're in Detroit, Michigan for a progress review hearing. Over 16 years earlier, 37-year-old Robert Osborne was convicted of assault and battery and brandishing a weapon. He was sentenced to a year of probation. But because Osborne allegedly failed to appear at hearings, his case has lingered in the court for years, despite a warrant being issued for his arrest. Today, Osborne appears remotely before Judge Elenice Bryant to review his case. He's represented by a public defender.
So I'm going to set the matter for review, see if probation can find his file, see if we can figure out what he has done and what he has not done. Mr. Osborne is going to come back to the court March 6th. March 6th at 10 o'clock.
It seems clear the defendant is not happy with the judge's decision to continue the case.
Old ass case, man.
I'm sorry, what'd you say? Come on, speak your truth, Mr. Osborne, because we're tired of the case too.
Judge Bryant doesn't appreciate Osborne's comment.
He bladed his body to the court, turned his head from the court, ignored the court when I was talking to him. So I just changed my mind. He's tired of the case, and so am I. We're going to just adjourn the case till tomorrow. Mr. Osborne is going to come in person, and we're going to close this case out. Anything further?
Judge, is there any way the court would... No,
I'm sick of the case too. And so tomorrow, we're no longer going to have to deal with the case. It's going to be over tomorrow, 8:30 a.m. Anything further?
Not at this time.
The next day, Osborne returned to court, this time in person. And he has a new public defender, Janice Stevenson.
Come on up, Mr. Osborne. So I promised Mr. Osborne that I was going to end his probation today. And today I am keeping my promise. The court is going to revoke the probation, sentence Mr. Osborne to 365 days in the Wayne County Jail on the brandishing and 93 days on the assault and battery. Sentences will run concurrently.
It appears the jail sentence has gotten Osborne's attention, and Judge Bryant isn't done with him yet.
You are convicted. You're convicted of assault and battery and brandishing. You have been an absconder from justice. You did not show up. You're the one dragging this out. You should have took care of this back in 2006, finished this probation and went on about your business. You the one keep dragging your past around, dragging it around like some unwanted dirty laundry. You're doing that.
Well, I'm asking the court to give Mr. Osborne an opportunity to demonstrate that he does want this matter from the past, squarely and solely in the past, without having to go to jail for a year and 3 months. And I think he sees that right now. There's too much on the line to not be thinking before we talk, so that he can put this matter squarely behind him, Your Honor.
After a final argument from the defense, the judge reconsiders.
Mr. Osborne, you changed your mind? You want to deal with it now?
Yes, ma'am.
Oh. I'll go back to what I said yesterday before all of this occurred, and I'll set it for March the 6th at 10 o'clock.
Osborne did return to court as scheduled for his review, but a report indicated he never completed the terms of his original probation, which included 12 weeks of anger management classes and paying court costs and fines.
Let's get it done, all right?
Yes, ma'am.
So the judge sentenced Osborne to 6 months probation so that he can finally complete his terms. The case was adjourned until a later date when Osborne's hoping to be officially discharged from probation. Next, we're in Battle Creek, Michigan for an enforcement hearing. 32-year-old Derek Wagner's being charged with civil contempt for not paying child support. The complainant, who appears without a lawyer, is 29-year-old Kelly Bridges, the mother of Wagner's 3 children. Wagner, who's currently in custody on an unrelated charge, has previously been held in contempt for failing to appear at a child custody hearing. He owes over $4,700 in arrearages. Today, he appears before Judge Brian Kirkham. He's represented by public defender Kevin Sackrider, who has some questions about his previous contempt sentence.
You bonded out on February 23rd by posting a $100 bond. Are you willing to put that bond amount towards your child support arrearages?
Absolutely.
He needs to pay more than $100.
Ms. Bridges, we're taking testimony from Mr. Wagner, not from you at this time, so please don't interrupt.
Prior to February 16th, were you employed?
No.
Lie.
Ms. Bridges, was I unclear about not speaking or interrupting?
So what, y'all can shake a piece of shit motherfucking hand and say congratulations?
Hey, ma'am, if you go off like that, you can be held in contempt of court and go to jail. Do you want to do that?
Just proceed through the court hearing and shut up.
Ma'am, one more outburst or one more vulgarity and you will be going to jail. You understand?
Good luck.
What, ma'am?
I said good luck. Finish court.
The judge remains patient and moves on, asking the defendant a few questions of his own.
In the last year, how much have you worked? Altogether, probably about 2.5 months. And during that time, you obviously didn't pay any child support. Why was that?
I just failed to pay. I failed to pay. I mean, honestly, there's no excuse for it.
The judge is now ready to make his ruling.
The court will find that he has had the present and the ability to pay, that he's failed or refused to pay, and therefore he is in contempt of court. I could sentence you up to 45 days. I'm not going to do that only because it is your first time that you would have any jail time. What I'm going to do is I am going to sentence you to 21 days in jail with credit for 7 days served. Court will end this matter. You're free to go. Have a good day.
Bridges is not pleased with the sentence, and she lets Judge Kirkham know it.
That's bull. You guys shake his hand and tell him congratulations.
Ma'am, the case is done. We don't need to hear anything else from you.
Bye.
Hold on, ma'am. The court. Miss Wills, do you have Miss Bridges' phone number? Can you contact her and get her back?
Yes.
Moments later, Bridges is back on the call.
Miss Bridges, I had warned you multiple times about your outbursts and your vulgarity, and apparently that did not have any impact.
You don't want to listen to anything I say. You just want to shake this motherfucker's hand and tell him congratulations. Let's be
Ma'am, the court is holding you in contempt of court. I'm sentencing you to 3 days. 3 days jail, ma'am. You will be sentenced to 3 days in jail. You will have to appear. If she fails to appear, the court will enter a bench warrant for her arrest at that point.
Bridges did appear and served her 3 days for contempt of court, while Wagner served his 14 days also for contempt. Next, we're in Genesee, Michigan for a civil hearing. Brandon Alexander is being sued by Genesis Regional Medical Center for over $2,500 in unpaid medical bills. 2 months earlier, Judge David Goggins issued a default order in favor of the hospital when the defendant didn't appear at a hearing. Alexander then later filed a motion to try to set aside that default order. Today, Alexander and the plaintiff's attorney Hal Burke appear before the judge to hear if the default order will be upheld. But first, Judge Goggins makes a suggestion.
the two of you talked at all? Would it help if I give you minutes to talk?
No, we're not going to come to an agreement.
Your Honor, I've been doing this for a long time, and I've never had the unique curse words that were used against me prior to this case being called. So I defer to you.
Okay. So with the default judgment, it sounds like you missed your date.
Yes, I showed up a day late and realized that I made a terrible mistake. I wrote down on 3 separate calendars that I had it on Wednesday. I messed up.
Judge Goggins once again suggests the two parties try to work it out directly.
If I give you a chance to talk, Mr. Alexander, if you keep a calm attitude, I don't mind the two of you talking, but we can get something resolved. If not, I'll just make a decision on the default.
To be honest, he does. There is no talking with this gentleman. It's how are you gonna pay? And then when I got his office calling me, the ladies, why won't you pay? Why won't you pay your bills? Why won't you pay your bills? Why are you not paying your bills? That's all I'm getting.
Your Honor, we do nothing like that. I'd ask that you rule on the motion.
For both your sakes, I guess I'll just make a decision. Give me just a minute. I'm going to review the pleadings.
After several minutes, the judge returns to make his ruling.
You have to show me, Mr. Alexander, that there's been some type of good cause to not enter the default judgment that was given. All you've stated in your response is that you were unable to make it to court. I have to follow the court rules for everybody. It has to also state a meritorious defense. In your claim, there's been no meritorious defense stated. Therefore, based upon the lack of good cause, the default still stands. Okay, good luck to both of you.
Burke has left the call, but Alexander still has a few things he wants to say.
Have a great day, Your Honor.
I'm sorry, Mr. Alexander. What?
I said, that's really not cool.
Well, I have to follow the court rules for everybody. Sir, I've got to follow the court rules.
What paperwork? Can he just come out and say, I'm not asking, but I'm asking, what evidence shows that I even owe that money?
I can't talk to you about the case, okay? I've made my ruling, okay? Good luck.
Well, then, can I appeal it? Can you tell me if I have an appeal? I can?
Appeal. Get an attorney. Yep, you can appeal.
So why is my word taken?
Sir, I'm not going to argue with you. I've told you my decision.
I'm not. I'm asking a question. I get no choice, no voice?
No.
Because I'm not a lawyer and I don't have a law degree, I get no voice.
You did.
That's the freedom we have as a citizen. You're going to treat me as a lesser citizen. You're going to treat me as a lesser citizen because I don't have a law degree. My voice don't matter. You're not letting me talk. You're just dismissing me.
Get an attorney.
I will, and I will sue you for what you're doing. Unfair.
Okay.
Unfair.
Okay.
Unfair, Mr. Goggins, and you should be ashamed of yourself. I will, because you're saying I have less a voice because I don't have a degree.
We're all done.
You're done. I'm not done. I'm not done with...
The hearing ends with the default order still in place. Ultimately, Alexander decided not to appeal, and the case is closed. Next, we're in Detroit, Michigan for an arraignment. 32-year-old Terrell Bell has been charged with domestic violence and 2 counts of assault. 2 days earlier, Bell got into an altercation with his girlfriend, and a neighbor called 911. When officers took Bell into custody, they say he began banging his head in the back seat of the police vehicle. Bell was taken to a hospital where police say he continued his aggressive behavior. He was treated for minor injuries and then arrested and officially charged. Today, Bell appears before Magistrate Laura Echartea to see if he'll make bond. But first, Bell's public defender announces herself on the record.
Crystal Marie Medina on behalf of Mr. Bell. With regards to the arraignment, we would waive formal reading.
Thank you, counsel. I'm going to enter plea of not guilty. I have 2 prior domestic violence convictions, 2018, 2021. I have prior felony convictions of assaulting, resisting, obstructing a police officer. Go ahead, counsel.
Your Honor, he understands that he is not to have any contact with the complainant in this case. My understanding is that Mr. Bell is a lifelong resident of Michigan. He has 2 children, ages 15 and 14. He is 32 years old. He is employed as a steward and cook. My understanding, Your Honor, is that he is unable to post a monetary bond, and any monetary bonds would be unaffordable for Mr. Bell.
Counsel, so I believe your client is a danger, not only to the complainant, okay, but to the community at large. So in this particular matter, his bond is going to be $50,000 cash. Affordable bond. So
How? How? How 50,000 posted? That's not even fair. That's a bunch of
Okay,
That's a bunch of
Your Honor, Mr.
That's
Bell.
a bunch of
Mr. Bell.
I gotta go to work.
Mr. Bell,
Man, I'm not supposed to do anything, man. This helping me.
Mr. Bell.
I didn't even do nothing. I didn't even do nothing.
Okay, Mr. Bell.
Man, what the then y'all gonna let these do whatever to me,
Mr.
man? That's
Bell.
not even fair.
Mr. Bell, you need to calm down, and we're gonna address this throughout your court dates, okay? You're gonna be able to address the allegations.
I got I have a job.
I understand, sir.
How do I supposed to do anything now? I gotta go to the county. That's what I'm saying. What? That don't even make sense. That's not making sense. That's not making sense to me.
Mr. Bell, you're going to get another court date this Tuesday.
For what?
So that day they will reconsider the bond that was just set, sir.
So I can't go to work and make my money?
Medina tries to calm her client.
Sir, I understand that you dispute the allegations, and I think it's pretty clear that you don't agree
That's not
with
fair.
what you're being charged
Nothing
with.
going fair. How I do anything to that girl?
Sir, this is not helping you right now. I'm sorry, this is not helping.
Mr. Bell, you're excused.
Man, you.
Come on out, man.
Okay, come on. Let's step out.
You.
Sir, step out.
Sir, let's go.
Sir, I don't think you understand how much work.
I don't give a you too. You ain't do.
All right, perfect.
As deputies return Bell to jail, he continues pleading his case.
Oh, that's some man. She didn't give me a chance. 50,000.
Come on out, Bell.
Come on, Mr. Bell. 50,000. How I'm gonna get there, bro?
At Bell's subsequent hearing, a new judge decided to continue his bond as previously ordered. Bell remains in custody, and his case is pending.